And Judge, the victim is logged on, Ms. Makai Strozier.
Got it.
Yesterday when we spoke, I'm not sure she'll actually speak today, but I told her I will at the end just ask. But I don't expect her to cut her camera on unless she chooses to speak.
Got it. I see the name on the Zoom and we'll make sure to check in there. This is an accusation that will supplant the old indictment?
Yes.
So when we're done today, you'll say you're gonna null process. We'll take care of that. Okay, so we don't need to do a plea on that.
Correct.
Okay, great. Then we're gonna get on the record. This is 26 SC 001-715, State versus Mr. Bond. Mr. Bond is here with Mr. Melnick, his lawyer. We have Ms. Willingham from the state. Mr. Bond, it's my understanding you are prepared to enter a plea to this accusation that charges you with family violence, battery, simple battery, and disorderly conduct. Is that accurate?
Yes, Your Honor.
Okay. Ms. Willingham is going to put you under oath in just a moment. She will be asking you a bunch of questions about your rights, this case, and your understanding of how this is playing out. You need to answer her questions truthfully and completely. You also need to let me or Mr. Melnick know if at any point you've got questions. Will you do that?
Yes.
Okay, then let's get started.
Judge, my apologies. Can you give the new case number one more time?
I sure can.
See.
It is 26 SC 001-715.
Good morning. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your true, correct, and legal name.
Terrell Monte Bond.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
46. College credits.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this accusation, including any potential defenses?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Have you reviewed the accusation in this case with your client?
I have.
And do you waive formal reading of that accusation?
We did.
Has your client been arrested on the original charges in this case?
Yes, he was.
And the state is unaware of any outstanding warrants related to that original indictment. Do you or your client know of any outstanding warrants related to that indictment?
I'm not aware of him.
And Mr. Bond, do you understand you're entering a plea to the following offenses? Battery, family violence, misdemeanor. Simple battery, family violence, that is also a misdemeanor, and disorderly conduct, which is also a misdemeanor. Each of these charges carry a minimum of 1 day and a maximum of 12 months.
Yes.
And the state's recommendation to each of those counts would be 12 months probation to be served consecutively, so one after the other, for a total of 36 months probation. And we would be asking for you to complete family violence intervention program, have no contact with the victim, and complete 80 hours of community service.
Yes.
Okay. And do you understand that although this is a negotiated plea, should the court not accept this sentence, they can sentence you to the maximum, which would be 36 months in custody?
Yes.
And do you understand that because this is a family violence conviction, if you are found in possession with a firearm, you could be charged federally?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of this sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you on probation or parole for anything, anywhere?
No.
And are you a United States citizen?
Yes.
Do you understand that there may be adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes.
Has anyone forced, threatened, or promised you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of battery family violence, simple battery family violence, and disorderly conduct in indictment 26 SC 001715?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today.
Yes.
Do you understand that you have only 12 months from today for a misdemeanor offense to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And Your Honor, I also stand corrected. The victim, that is not the victim in this case.
I didn't
My
think so.
apologies.
Her name was Whitney.
Yeah, you were gonna get some follow-up of
Yes.
it's Ms. Blanks,
It is
and
Ms.
I was wondering, maybe there was a name change, people can do
That's kind
that.
of what I thought too. Maybe she had,
No,
yeah.
my apologies, Judge. That is a victim in another case.
Okay.
So my apologies.
So
All right.
she's not on is what you're saying.
I do not see her on. She was made aware of today's hearing and provided with the link should she want to join.
Okay,
Hit my notes. Oh, Your Honor, if this case were to proceed to trial, the state would expect to show that officers arrived at a dispute call at 4338 Schaefer Court in South Fulton, Fulton County, Georgia, and they heard arguing coming from inside the residence, but no one answered the door. They then heard a woman, later identified as Miss Whitney Blanks, yell for help and stuck her head out of an upstairs window, yelling that her fiance, Terrell Bond, was not letting her leave and that she needed help. Officers also saw Bond come to the window and pull her away. Officers made forced entry at that point and saw Blanks and Bond come downstairs. Bond was detained and Blanks told officers they had been in an argument that turned physical about her infidelity. He had slapped her and choked her to the point that she could not breathe. Every time she would attempt to leave the room, Bond would physically block her, keeping her inside. Bond was Mirandized and denied the events as Blanks recounted them. Blanks had bruising under her right eye. Bond and Blanks did live together at that time. Your Honor, I've had an opportunity to speak with Miss Blanks. When she initially spoke with our office back when this incident first happened,
there are two different dates in the accusation. Was it two different incidents, or
No,
that's
it was
just a
just one.
typo?
that might have.
Probably
do you-
typographical.
I was
Okay.
just gonna
Yeah,
say,
we'll waive any
waive
defect
any
in the.
defects. Thank you.
Okay,
Yeah, no, we don't need to come back on this case.
we don't. So it was all one incident,
It's one.
exactly what you described, argument that got physical over a perception of infidelity. Unfortunately for Mr. Bonds, some of the argument happened with where the police could see it. They bust in and do what they do.
Yes, Judge.
Okay, and what does Ms. Blanks say?
Ms. Blanks maintains now that this incident happened the way that it was reported. Back when she first spoke with our office, that was not
Yeah.
what she stated. And as your honor is aware, that is not uncommon in domestic violence cases. That was actually one of her concerns. But she did state that part of the reason for doing that back then was, and I addressed it, I believe, at Mr. Bond's bond hearing. Part of her reason back then was because she just wanted the defendant's family to stop reaching out to her. She thought that that would stop it. But she does recognize that based on this charge originally came in as a battery family violence. And that was the stronger charge in the state's opinion, as opposed to the aggravated assault. And as to the false imprisonment, she does recognize that the change can not necessarily be favorable in the state's case. So with that, we decided that this was a fair resolution. She was comfortable with the fact that we were at least adding another charge. Her preference, of course, would have been for the defendant to get in custody time, but she also recognizes that he has been on an ankle monitor for quite some time, and that was part of our discussion as to why the state believed that this was a fair resolution. So although she doesn't completely agree with us, she does understand the reasoning behind why we have made this offer.
Okay. And do Ms. Blanks and Mr. Bond have any ongoing connection, kids, shared property that
Based
you're aware of?
on my conversation with her, the last time they spoke was roughly a year ago, and they have no reason to interact anymore moving forward.
Okay, so no contact doesn't create complications.
Correct.
Shouldn't create complications.
No, my client is in agreement with the no contact provision.
Great. Okay. All right. What can you tell me about criminal history?
18 cycles.
18 cycles.
So that's 2026 failure to appear. 2011 unlawful for a person to purchase, possess, or control substance and sell marijuana conviction. And you got an 01 distribution of crack cocaine conviction. That's
All right. Thank you. Mr. Melnick?
Thank you, Your Honor. In addition to the time that Mr. Bond has spent with this ankle monitor on since, I believe, July of 2024, he also spent a fairly a fair amount of time in custody. I think it was about a month or month and a half before he got a bond initially. Bond was with the ankle monitor, and then you may remember there was a bench warrant because he missed an ankle monitor compliance hearing in December of 2025 that was in front of Judge Manning. And you had agreed to set that bench warrant aside, but he still spent about 2.5 months in jail on that. So all told, he's done about 4 months in custody on these charges. He is gainfully employed, Your Honor, and as I indicated, he and Ms. Blanks have no real connection to one another other than their prior relationship. So he's in agreement with the no contact provision and will abide by that. And his main concern today is he wants for me to ensure that he can take the ankle monitor off today, which I've told him that he will be able to take the ankle monitor off today.
Okay.
Yeah.
Mr. Bond, what's your job?
I have a box truck company, owner operator, I'm sorry.
Okay. You drive a box truck, or you own some and other people drive them for you?
Both.
Both.
I have a couple trucks, so I drive one and I have someone else driving the other one.
Got it. What do you typically deliver?
Just general logistics from everywhere.
Okay.
You know,
How long have you done that?
I've been in trucking since 2018. I started driving in 2023.
Okay. And you and Ms. Blanks haven't had any communication or overlap, it sounds like, for almost a year now.
No, sir. No, Your Honor.
All right. Do you even know where she lives these days?
No, Your Honor.
Good. The ankle monitor, you will be able to get off as soon as Mr. Melnick gets you a copy of the final disposition. So I don't know that that's today. I'll sign it today and we'll get it there. But you'll need to go to second chance and Mr. Melnick will tell you where that is. You may already know where it is, but I just want to manage your expectations. You aren't removing it. You should not, because you're pleading guilty, go home and with cutting shears, remove it. You're just going to want to connect with the ankle monitor company with a copy of that final disposition that says case closed. And then they will take it off and they'll be happy to get their device back. You'll be even happier to have it off.
Yes, Your Honor.
All right.
Yeah.
Do you have any questions about the things we've discussed?
No, Your Honor.
Okay. Well, Mr. Bond, I find there's a factual basis for your plea. You and Ms. Blanks got into it that day in a way that I'm going to say you shouldn't have. I don't know what she said or did, but in the end, this is on you. And you're going to need to manage those kinds of relationships differently going forward. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about, told me no questions, and voluntary, meaning no one's forcing you to enter this plea. Do you agree with that?
Yes, Your Honor.
Mr. Melnick, can someone in my office sign the accusation on your behalf?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
And can we sign for you indicating your guilty plea to the 3 misdemeanors?
Yes, Your Honor.
We'll do that. Ms. Willingham, are you moving to null pros 25 SC 005850?
Yes, Judge.
All right, Ms. Nelson will take care of that. The jail system shows a little less time in custody. It was 75 days total. That's still a long time. I'm not minimizing it, just it wasn't quite 4 months. But I'm going to give you credit for that time in this way. Your sentences to count 1 will be 12 months to serve 2 months with the balance probated. Count 2 is going to be 12 months probated consecutive to count 1. And count 3 is 12 months probated consecutive to count 2. So it's a total of a 36-month sentence, but 2 of those months you've already done because you were in custody originally, bonded out, in again because of this ankle monitor issue. And those 2 months are backed out of the 36 of probation. So it's really going to end up being 34 months of probation. Special conditions of probation, there are 3 of them. The most important one is that you continue to have no contact with Ms. Blanks. Don't look her up, whether it's to say I'm sorry or if I ever see you again, I'm going to get you again. None at all. And if for some weird reason you guys bump into each other, just walk away. She needs to have you out of her life, and that means she's out of your life. Special condition number 2 is that you'll complete a family violence intervention program. That isn't just one class, it's a series of classes. And I'm requiring that you enroll in FVIP within the first 3 months of your probation. So it's April now. By July, you need to be in the program. Not finished it, but you need to have started the program.
Okay.
And finally, you need to complete within the first 6 months of your probation, 80 hours of community service. We're not going to wait for 2 years and then probation reaches out to me and says bond hasn't done it. You need to do it within the first 6 months. So they'll reach out to me if we get to November and you haven't done your community service. Probation can bug me to bring you in here to say, you know what, I'm going to actually just add more community service because you didn't do the first part you were supposed to do. So get that out of the way. By the end of this year, probation is going to be a real low-key thing. You'll have done family violence intervention program. You'll have knocked out your community service. And as long as you're staying out of trouble, probation is going to be staying out of your way. Okay?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Mr. Melnick, you and Mr. Bond need to fill out that form, and then you leave that form with me. And Ms. Nelson will get it to misdemeanor probation. And you, Mr. Bond, will get a call or an email from misdemeanor probation. This form you're filling out is your contact info. When they reach out to you, they're going to tell you how to connect with them. Do it. Don't say, I'm too busy, I can't call you, or I can't swing by. Generally, they don't require in-person meetings. They may for the very first one. The good news is, since you were able to find this building, misdemeanor probation is about a block from here. And you'll plug in with them in that way. Okay?
Yes, Your Honor.
Ms. Willingham, anything else?
Nothing from the state.
So go ahead and fill that in.
Mr. Melnick, anything
No,
else?
Your Honor, thank you.
That's it. Good luck, Mr. Bond.
Judge, I'm going to need just a moment to talk to Mr. Smith before we get started on the
Okay.
case. So if you want to take up the other one.
We will. We've got Ms. Brown on the call. Good morning, Ms. Brown.